Generating traffic and sales can be a challenge for online merchants. But selling on the Walmart Marketplace puts your products in front of millions of customers who shop on Walmart.com. And right now, sellers who join Walmart Marketplace can save up to 50% on referral and fulfillment fees for the first 90 days. So get started today. Head over to marketplace.walmart.com/savings. That's marketplace.walmart.com/savings.
Welcome to E-Commerce Conversations, a podcast by Practical E-Commerce.
This is Kerry Murdoch with Practical E-Commerce. The recent South Dakota versus Wayfair decision by the U.S. Supreme Court changed online sales tax in the U.S. To discuss the details of the decision and its impact on e-commerce merchants, there's no better observer than Shane Radigan. He's a CPA, attorney, and longtime nationwide authority on online sales tax matters, and he joins me today. Well, Shane, thank you for speaking with us.
Thank you for having me, Kerry. I appreciate the opportunity.
Shane, we are here to discuss the Supreme Court decision last week that overturned the long-standing Quill precedent for sales tax. Certainly that decision has received a lot of press, and I wonder if you could tell us about the actual decision, what was decided, who was the plaintiff, defendant, that sort of thing.
Sure. Yeah, it's a great time for sales tax folks like myself to find my particular sliver of the tax world on the front pages of newspapers all the time. The Wayfair case was a very deliberate case, Kerry. The state of South Dakota purposely passed legislation in violation. The legislation contained rules which were in violation of what at the time was Supreme Court precedent, the Quill case, as you mentioned. The state sent this test balloon out, if you will, partially in response to some language that Justice Kennedy had inserted in a sales tax case from a few years ago, Kerry, but it wasn't decided. That particular case wasn't decided on the merits, but it did concern sales tax. And at the time, Justice Kennedy took the opportunity to invite the legal community to come up with a proper case for the Supreme Court to actually redecide what was the physical presence standard in Quill. So the state of South Dakota took the opportunity, took the bait, depending on how you want to look at this, and created legislation that was specifically designed to fast track through South Dakota courts, meaning the legislation contained literal specific instructions on how the case was to work its way quickly through the South Dakota courts. And sure enough, it did, and the state lost at every turn, which ironically is exactly what they wanted. They knew they had passed a law that was violent of Quill. In order to find some plaintiffs, the state identified actually at the time, three online providers, Wayfair, Overstock, and Systemac. That third one actually didn't do what South Dakota wanted. They actually capitulated and registered and started collecting. Yeah, right. Yeah. Thank you for collecting, but that's not really what we wanted this time. Newegg got involved as well, I think, and not having real insight into exactly how this went down. It looks to me like there were probably no surprises on either side, meaning South Dakota passed this law with complete knowledge and understanding that they were passing a legislation that was violative of Supreme Court precedent. And I think the defendants in the case, the e-com providers, I would guess that they were at the very least given a little notice so that they could participate in this, because I think the desire for some surety or some clarity on what the future was going to look like was held by both the states and the regulated community in this case. And I don't know that the case went the way everybody wanted it to. You can never have everybody happy. But I would think that the genesis of that case was probably done with some communications going back and forth between these plaintiffs and defendants. And they did what they set out to do, Carrie. It's pretty remarkable, really, that within an 18-month period, that law was passed, worked its way through the South Dakota courts, including the South Dakota Supreme Court. Cert was granted by the U.S. Supreme Court. We have a decision. I mean, it's remarkable that it went down that fast. So South Dakota was successful in what they tried to do.
And the South Dakota law that they passed did what? How is that different?
Sure. The crux of the law, Carrie, is it changes the manner in which we allow states to determine who's obligated to collect their sales tax. So there's a pretty twisted English sentence, and let me see if I can unwind that a little bit. So prior to the Wayfair decision, and anyone who's been around the sales tax game at all recognizes these concepts that I'm about to mention, and that is, in order for a state to obligate an out-of-state vendor to collect its sales taxes, it needed to prove or assert that out-of-state vendor had some sort of physical presence within the taxing state, the state where the customer is. Mm-hmm. And that case was decided, frankly, even prior to Quill. Quill was an affirmation of an even prior case. And at the time, even at the Quill time in 92, the justices, they really thought that they were drawing a kind of a line in the sand with coming up with this physical presence test. But Carrie, as you know, folks that have been around this know, the states really went to work almost immediately, trying to kind of tug and pull and massage that concept of physical presence in order to gain more collectors. And the result was, after a number of years, besides the social policy issues of who should pay and who shouldn't, maybe leave that for the pundits to concern themselves with, but it created a lot of diversity between the states in determining what was a nexus creating activity, and it also created an opportunity for businesses to game the system is probably too harsh of a term, but it allowed companies to operate in a way that was specifically designed to avoid the collection obligation. And for that reason alone, businesses were planned and designed, and that's kind of poor tax policy, right? So what Wayfair did is it upended that physical presence standard for sales tax collection obligation and replaced it with what we call, or what's known as, an economic nexus analysis. And it's about what it sounds like. So instead of, under the Quill doctrine, of determining if a remote seller had employees in the state or had inventory in the state or a brick and mortar store or a click-through affiliate advertising agreement, this physical presence got pretty crazy towards the end. Now, under Wayfair, the analysis is more simple. It is how much revenue is derived in that state by that remote seller once a particular threshold has been met over in a certain period of time. We can talk about that detail a little more later. That triggers the obligation. Your nexus is now triggered as a remote seller, and if you meet the thresholds, you are now obligated to register and comply with South Dakota's laws. Let me mention right now that we're focusing a lot on South Dakota for a couple reasons, right? One of them is they were the plaintiff in the case, right? So they were front and center in Wayfair. But the other reason has to do with the way the decision is written. And again, we can fill in a little more of these blanks as we go. But the Supreme Court really focused on some elements, some attributes of that South Dakota law as written in an approval. And so they sent a not very subtle signal to the other, 49 states, but 44 states plus D.C. that have a sales tax. That is, the signal is, if you don't want to end up back here in the Supreme Court arguing about constitutionality and discrimination against interstate commerce, write your laws like the South Dakota law. So my perception is, and I think other professionals' perception is that that South Dakota law is very likely going to be a model for many other states for that reason. States they want to avoid a major challenge. So,
interesting. What's the immediate impact? To follow up on what you just said, what's the immediate impact to merchants nationwide? I mean, so if they sell to South Dakota, does this go into effect? Has it already gone into effect if they're selling into South Dakota? Plus, then what happens with the other states they sell into?
That's a great question. There's a couple of layers there. So let's talk just about South Dakota. I would say that maybe not just theoretically, but theoretically, I'll use that term, or technically, that is good law right now in South Dakota. Whether or not the state will enforce the law from June 21st going forward, I think practically speaking, probably not. But I would look for publications and or announcements from the state of South Dakota very soon. It's summer, right, and it's July 4th, but I imagine this is pretty important to the folks at the Revenue Department. And I think you're going to see really soon some publications that are going to give some more specific light on when this is going to start to be enforced. But I would say from actually probably not even a terribly conservative point of view. I think the more realistic point of view, that if you are selling into South Dakota now and you're not registered and you meet those thresholds, meaning this year you're going to sell more than $100,000 into South Dakota, or you're going to have more than 200 transactions, it's time to act. The other layers that we're talking about really refer to the other states, right, Kerry? And of all the states with a sales tax, only about 16 or 17 of them have passed similar laws to the South Dakota law. And this has just been done in the last year or so, right? The states are all kind of sitting around watching what's happening. And in the meantime, that little more than a handful of them have passed similar laws. They will be the states that we would look to next after South Dakota to again give us an indication of when they're going to start enforcing these rules. Some of the laws are written, Kerry, with an effective date portion of the law that says this law is effective when and if the Supreme Court ever overturns Quill.
Wow.
I'm paraphrasing, but that's so. Some of these have really,
pretty aggressive.
They protected themselves,
Yeah.
So all that being said, yes, the sands are shifting fast and businesses are going to have to react. I don't believe that it would be prudent at this time. I know it's not prudent to make a blanket statement that it's time for all vendors to register everywhere and begin collecting everywhere. What we have now is a new Nexus standard, a new way to look at where obligations to collect may pop up, but it is not a blank check. And I think reading a lot of the newspaper type articles, written by folks that maybe aren't tax pros, it's easy to get the impression that, starting tomorrow, everybody everywhere is going to collect, and it's not true. And so I think a urgent but measured approach is proper for most companies. For mega size, huge internet retailers that have been relying on that Quill standard for years to not collect here and there, it's probably more urgent for them. They're going to be in the crosshairs. But for businesses that are not in that enterprise level and are more modest in their total sales and perhaps very modest in places like South Dakota where you don't have a big population, it's time to reassess what the Nexus obligations for your company might be. They're not going to be reduced as a result of Wayfair, Kerry, in any way. And if you're an e-com provider, you're going to be collecting in more places. But I think that it's more of an adjustment in how we look at it and an increased sense of urgency. But it doesn't mean that everybody needs to rush out tomorrow and register everywhere and begin collecting. That may be an appropriate strategy for some companies, Kerry, but probably for smaller businesses it isn't. We're dealing with these thresholds. Risk and exposure needs to be balanced, and the cost of complying. It's time to think very seriously about these questions. But for most folks, it's not necessarily time to stop everything and register everywhere this week.
You mentioned that the court used the South Dakota law as essentially a model, if I could paraphrase what you said. Um, what aspects of the law are you referring to there? Is it the thresholds that you're talking about, or is there something else about that law that other states are likely to follow?
That's a great question, Kerry. And there's really three major components of the South Dakota law that the court liked, or the court said, these are the things that make us feel that this approach is okay. And the decision is a little scattered. There's some social justice in there. There's some building local roads and bridges. The justices on the majority side, written by Kennedy, really touched on all these kind of outlying policy issues. But for the real nuts and bolts of it, Kerry, they looked at the South Dakota law and they said, this accomplishes what we think needs to be accomplished, and there's three reasons why. And the first one is what the court calls the small seller exemption. South Dakota doesn't call it that, but I think it's a great paraphrase, and that is the threshold. It's a de facto small seller exemption. So if you're selling less than $100,000 a year into South Dakota, or not reaching 200 sales transactions, this doesn't change anything for you. In fact, in some ways, businesses who had $80,000 a year in sales last year in South Dakota and 150 transactions, Kerry, and had a salesperson there, they were obligated to register and collect under the Quill standard. But actually now under Wayfair, they're not.
Okay.
So for a small sliver of folks, this is maybe good news. I don't know about in the long run, but in the short run, I think that's true. The other, a second element that the court really liked about the South Dakota law is it's specifically not retroactive. So South Dakota's law says this law will not be effective retroactively. Now, I would say, probably technically again, and probably true, we'll see how the state deals with this. I would say that retroactive protection probably ended on Thursday. You know what I mean? So it can be retroactive, but that date is passed for South Dakota now. But the retroactive nature of it, and I'm kind of making light of it. I mean, what we're really concerned about in the last 7, 8, 10 years, when a state under normal circumstances can go back and look and assess for past periods. They can't assess based on a nexus finding based on the Wayfair standard. So the state cannot say, oh, you had $100,000 in sales in 2015. We're going to audit you for 2015. You should have been collecting. The law precludes that, and the court really liked that about it. The third thing that the court liked about the South Dakota law was that South Dakota is a member of the Streamlined Sales Tax Governing Board. And Streamlined Sales Tax here's the nutshell version, is a voluntary group of states, Department of Revenues, 23 of them, with a sales tax, who over the years have gotten together and tried to standardize some of the more prickly elements of sales tax compliance. And frankly, they've done okay. For a voluntary organization without any necessarily deep pocket funding, without any real political clout or power of its own. They've been able to pull together amongst those states some common definition language. For example, yellow widget in one SST state is defined in exactly the same way as a yellow widget in another SST state. They've also been able to simplify tax filing obligations. Back in the day, 15 years ago, that meant when SST first got off the ground, that meant providing an online portal. It sounds quaint now. Everybody's got an online portal, but that was one of the things that they did early on. And without going too far down that road, Kerry, that's the third element that this court really liked about that South Dakota law. Now, on that third element, the court did not say explicitly, or I think even implicitly, that in order for a state to take advantage of the Wayfair decision, in other words, to start asserting nexus based on these economic nexus principles, they don't have to be a member of the SST, Streamlined Sales Tax. But doing the types of things that states have done who have joined the SST does sound like an obligation on the part of the states. who want to enforce these types of rules. So those are the three pieces. And again, you're going to hear probably a lot of this, and that is we're kind of waiting to see how this shakes out. It sure did give in my view, the states that are already members of the SST, like South Dakota, a leg up. They're kind of sitting in what I would call the catbird seat, right? They as long as they pass a law that's not retroactive and has thresholds which are similar, as I would say exactly, unless they really want to pick a fight, exactly like the South Dakota rules, and they don't apply it retroactively, and they are a member of SST, they can really get the ball rolling on these rules and enforcement of them very soon, Kerry.
And that was 14 states? Is that 14? Is that what you said?
No, SST is 23.
Oh, 23. Okay. 23.
Yeah, 23 states,
Yeah, wow.
including South Dakota, yeah.
Are there some big states? California, New York? Do you remember?
No, that's a good question. And probably, if you're a follower of state politics at all, you won't be surprised to learn that none of what we would call the big commerce states are a part of Streamlined. I would say Michigan is part of it, and I think that's probably the biggest state in terms of kind of gross domestic product. So, no, New York, California, Texas, Florida, they are not members of SST.
Now, the small seller exemption, as you described it there, is that, make sure I say this correctly, is that a permanent exemption? Or is that an exemption just from collecting and paying, but the consumer is still obligated to report it?
That's a great question. Yeah, the ruling in Wayfair, which refers to those thresholds, only refers to the obligation of the seller to collect the tax. Nothing in Wayfair eliminates or alters the consumer's obligation to remit use tax on anything they buy that they don't pay tax on, whether it's from an e-com provider or any other situation where they have purchased something that is otherwise subject to tax. The item is still the tax should be remitted by the consumer. Now we know, and even Justice Kennedy alludes to this in the decision, that the consumer remitted use tax is likely the most evaded tax in the history of the world. And, nothing here is likely to change that, Kerry. Of course, I self-remit on everything that I purchase online where I don't pay tax, of course, but, most people don't. Right? But the rules haven't changed. So that's a great question. Yeah.
So if
I'm still obligated. Yeah.
If I'm a consumer in South Dakota and I buy, a couch online and it's shipped to me, and the merchant is under the threshold that you just described to selling to consumers in South Dakota. As a resident of South Dakota, under the new law, I am still legally responsible for paying use tax on that couch.
That's right. The decision, exactly. Yeah, the decision doesn't affect the taxation of any given transaction. It only affects who's obligated to collect it.
Got it. Okay. I know you've explained, Shane, you patiently explained to us over the years the various U.S. congressional initiatives to address the sales tax issue. In light of Wayfair, do you anticipate all of those initiatives going away, or do you expect a response from Congress?
Well, let's see. Here's my really brief statement on the U.S. Congress for the last 25 or 30 years, and I think a lot of people would share this no matter what your politics are. They haven't been great at solving big problems, right?
Yeah.
So I think there's a disinclination on the part of tax pros to think that they're going to be able to all of a sudden snap to. That being said, the proposals that have gotten the most traction to deal with this issue in the U.S. Congress over the last 10 or 12 or even 15 years don't sound all that dissimilar from Wayfair, right? The Marketplace Fairness Act and the Remote Transactions Parity Act both set up a threshold, a small seller exception, prevented states from applying the rules retroactively, and encouraged the types of improvements and changes in states' methods of filing that the SST requires. So, no, there have been, besides those two, that have gotten the most traction. There have been other proposals in the U.S. Congress which would have, for example, frozen the quill standard. I just don't see that sort of radical undoing of this decision, Kerry. This, of course, is my opinion, but I don't see that. And given that the proposals in Congress, which had attracted the most support, in fact, the Marketplace Fairness Act passed the U.S. Senate in 2013. It was, a House vote away from becoming law. The thresholds are different, Kerry, a little higher, the small seller exemption. The language is a little different, but, essentially it's the same outcome as Wayfair. So I don't see the U.S. Congress acting in any sort of global way to either alter or undo this decision. I have a feeling that this is going to be the lay of the law for some time when it comes to collections obligations for sales tax.
To follow up on that, ask your views. You're a nationwide authority on this topic. You've helped us so much over the years. What is if you don't mind my asking, what is your opinion on the case? What is your opinion on the merits of the decision?
I think Justice Kennedy really wanted to fix Quill, and he was on the winning side, by the way, on the Quill decision in '92, which was decided not so much on the merits, but on an idea of sustaining precedence, right? So that being said, I find his decision in this case to be, like I mentioned, a little rambling and a little seeming to want to kind of get it off his chest, right? And I'm not a really close Supreme Court watcher, but I got that impression reading it. On the other hand, the way that the court built up its argument and stated, this is for the people who really follow this stuff, stated that the physical presence standard is not required under Dormant Commerce Clause jurisprudence. And that's all they needed to do, Kerry. This decision could have been, instead of 40 pages, it could have been 3. So I think there's a lot of material in there, a lot of Kennedy, I think, frankly, proving his point. And he does a pretty good job of it. But there's a lot of policy talk in there, and you don't often, and a lot of times you don't get any of that in a Supreme Court decision. So it's unique in that way. But all that being said, that's just me kind of spitballing. I'm not a really close Supreme Court follower, but I like to keep up with the personalities on the court. And this is a classic Kennedy kind of decision. He's kind of straddled the fence when it comes to the right and the left. He's kind of shooting from the hip a little bit, and he's definitely got some heart involved. He's got a belief in this. But when it comes down to the legal nuts and bolts, they said the magic words, Kerry. And there's not, they really didn't, they left a lot of room open for argument about the whys and the policies and the who benefits and the who loses. But when it comes to the law, they sealed it up, and they said they are changing their approach when it comes to sales tax nexus, and physical presence is simply no longer a talisman, no longer a requirement in order to avoid discrimination against interstate commerce. So I think they did what they had to do. I think they did it in a way that took a lot longer to read and get through than it had to. How's that?
Okay, yep. Okay, that makes sense. So we've got just a couple of minutes left. Anything else? Anything else we need? Obviously, our listeners are e-commerce merchants, mainly small to mid-sized merchants. Anything else they need to know about all this?
Well, pay attention to what's going on and find, appreciate y'all taking the time to listen to our podcast today. Kerry's site and his resources, he's always got smart people on there talking about this stuff. So pay attention to what's going on. That's the lesson of
Well, thank
the
you.
first advice is, if you're listening to this podcast, you've already found a pretty good source for keeping up with this stuff, because there's going to be a lot of things that happen in the next 30, 60 days. It almost is inevitable, Carrie. The second thing I want to bring up, and it may not be the most important thing to everybody, but keep in mind, folks, that Wayfair does not change the past, meaning, yes, it's not retroactive. We got that. However, if you are a company that has had a physical presence in a state for years, you still have to deal with those past periods. And this is startling to me, Carrie, but I've already heard this in talking to other outlets and other professionals who are having clients that are asking about this. And there's an instinct for some clients that we've heard, clients meaning e-com providers, to say, oh, wow, cool. I've been worried about state X for years because I've had an independent contractor there, and I've been nervous, and now I don't have to worry about that anymore. And that is not true, right? The Quill precedent was law until June 21st, 2018. And we'll see how aggressive the states are at looking at past periods, but I don't think they'll be any less aggressive than they are now. And so if a state can assert that your company had a Quill presence in a prior period, you might be on the hook. So looking still at voluntary disclosure agreements or a strategy to try to close down some of these open periods in states where a physical presence may have occurred in past periods still remains an important strategic analysis that businesses need to make. And that's probably not the most important thing on everybody's mind, but I've heard that a few times already in the last couple of days, and I'm concerned. I don't want people to think that. That going forward, this is the new law. But if you've got past periods where you have concerns over whether or not you had nexus, and whatever your decision is, don't abandon those concerns, because they still are valid. And part of this game with sales tax is sometimes it's not just looking forward; it's looking back as well, and it's kind of a CYA exercise, if you will, Carrie. And I just want to make sure people aren't forgetting about that.
That's a great point, and I didn't even think of that until you mentioned it. So, what about the pending cases? Pending cases that perhaps arguing about a state's definition of a physical presence. What happens to all those cases?
Well, that's a good question. I don't know for sure. However, here's what I would say: the state has no interest in dropping those cases unless they just decide they don't want to spend the money and pursue them anymore. But if it's in my small example earlier, if I have a little e-com company out here in Edmonds, Washington, and in 2016 and 2017 I had an independent contractor working for me, or helping refer sales to me even through a website or something. In other words, I had a physical presence in a state, and I wasn't registered at the time. I'm still running the risk of exposure of an assessment for those periods. So to me, the states may address this somehow, and they may say, some of these rabbit holes we've been chasing down, we're simply not going to bother with anymore, because we're going to be really busy registering all these new businesses. But there's no edict, and there's no principle on which they would be required to do that. So I don't think these cases are going anywhere. If the state thinks they have a good case, they're going to pursue it, Kerry.
Okay.
For past periods,
Okay.
Yeah.
Well, I've been visiting, for purposes of our listeners, I've been visiting with Shane Radigan. Shane is Senior Manager, State and Local Tax for Clark Nuber. Clark Nuber is as he mentioned, a Seattle-based CPA and accounting and consulting firm. Shane is a nationwide authority on sales tax. He's helped us out a lot over the years. The Clark Nuber's website is clarknuber.com. Nuber is N as in Nancy, U, B as in boy, ER. clarknuber.com. And Shane Radigan, thank you as always, sir, for your time.
Hey, thank you, Kerry. It's always nice chatting with you.
Thank you.